Well, good afternoon. Happy Thursday, everybody. Bill O'Leary coming to you live from Legacy Planning Law Group, an estate and elder law a planning firm and a probate firm as well. So, coming to you live here Thursday afternoon as part of our Thirsty Thursday series, where each Thursday I go live, talk about a different topic that may be in the news, maybe something that's come across the legal wires, something that I'm interested in, maybe a client experience we've had, sort of a topic of interest that I want to share with you. So if you're thirsting for knowledge, you have come to the right place. Now, today's topic, it's an interesting one that we see from time to time. A question we get is, can a bank refuse my POA, my power of attorney? Can a bank refuse my POA? And if so, how can I dispute it? So, a little background. A power of attorney, also known as a POA for short, it's a legal document that gives someone the right on your behalf to act for you. More precisely, a POA allows someone that's called an agent to handle various financial affairs on behalf of the person who signs the POA, and that person is called the principal. So you've got the principal, the person that signs the POA, and the person that is being granted the authority is called the agent. Now, sometimes financial institutions like banks, they just refuse to honor the POA document, and they won't work directly with the agent. So again, can a bank refuse a POA? Well, the answer is yes, maybe. The answer is yes, maybe. Look, don't be sort of lulled into or seduced by a false sense of security about maybe the power and authority that a POA gives. Whether you're signing a POA to allow someone else to handle your affairs, or maybe you're the person who's been named as the agent under a POA, just brace yourself. Be prepared for the possibility the POA might get rejected. Okay? It doesn't matter if your POA was drawn up by the best lawyer in town. A bank still may, not trust the agent that walks through the door holding that POA in hand. So you just need to plan ahead for that. So, look, understand, banks aren't just throwing their weight around just because they can. They actually have a responsibility to protect people's finances. Most of us have heard about tragic stories of fraud, theft of senior savings, sort of exploitation, financial abuse of our seniors, and compounding sort of this hesitancy that banks have is that family members a lot of times are the problem. They're the culprit. And so it's an especially tough job these days for banks, and especially with online banking and banking machines. You as the person who wants to sign a POA, or your agent that may be unknown to the bank outside of an online account or two, well, it makes it a hard job for the bank to sort of navigate and figure out what's what. So because of this lack of familiarity with maybe the agent that's been named, sometimes the pendulum swings too far and the bank just refuses, inappropriately so, refuses to recognize an otherwise legitimate POA. So what are some reasons that banks give for rejecting POAs? Well, it's too old. That's usually not a good answer, but it's too old. It isn't clear, or maybe it doesn't conform to the bank's internal policies. I've heard of stories where a bank refuses a POA even though it's otherwise a good one or valid for these kind of reasons. Well, hey, the son who was named as the agent under the POA, the bank never met them. The POA was more than 10 years old. The person with the account didn't arrange to sign the bank's own internal POA papers. Maybe the parent wasn't physically able to go to the bank to verify that their son or daughter had a POA. How about this? A sibling called the bank and said this was a case of financial abuse. So, technically speaking, you don't always need a lawyer to draw up a POA. In fact, there are free kits available online that you can complete them without a lawyer. Having said that, you really should have a lawyer. Why? Well, in my experience, banks are even more suspicious with sort of do-it-yourself powers of attorney. Even though they still might be legal, although even there that's suspect, but still they're very hesitant about do-it-yourself online products. It's also a good idea to have a lawyer sort of complete your POA if there's even a hint of conflict between family members. Think of maybe disagreement among siblings. Doing the POA the right way is the right way to go. This is no time to be sort of sentimental or naive about the process. Now, don't misunderstand me. This isn't fear-mongering or sort of a tirade against banks. I've simply heard of too many experiences with sons and daughters who have had a legitimate POA denied by the bank. You can imagine the stress that is sort of involved in this situation. The bank can freeze accounts, right, in order to maybe investigate what they consider to be suspicious activity. This can make it even more difficult for the agent to pay mom or dad's bills. So, is there anything you can do if a bank refuses a POA? Well, thankfully, yes. Florida law gives us an option. In 2011, about 10 years ago, Florida passed a new power of attorney law that significantly changed the previous POA law. The goal of the new law was to achieve greater consistency and uniformity throughout the state. And one big change that the new law brought was to become, so things would become more clear to the banks and other third parties, sort of a bright line. When can they reject a POA and when can they not, and to provide some sort of recourse if they do it improperly. Now, this law says that once a POA is presented to a third party, let's say a bank, the bank is required to accept or reject the POA within 4 business days and give a written explanation for the rejection, if that's the decision, unless the bank might otherwise not be required to engage in a transaction with the person that prepared the POA. So the problem lies in where a bank maybe questions the POA or the authority of the agent and then refuses to honor the POA. It's first of all important to understand that banks have some protections that encourage a bank to accept a POA and accept it as valid. Florida law says that if a bank accepts a POA that appears to be valid on its face, the bank is not going to be liable for accepting the POA if it turned out that son or daughter was using it for improper motives. The bank will only be liable if it in fact knows the POA has been revoked and still accepts the POA anyway. So with the new law, the legislature in Florida wanted to encourage third parties to accept POAs, okay? Because a POA is a wonderful tool. It allows a principal to plan ahead by authoring someone else, again, the agent, to act on their behalf. So, the POA, it's a powerful estate planning tool that can save a family time and grief. So, yes, Florida law likes POAs. It also likes POAs, the law does, because it saves the court system time by not forcing courts to get involved in guardianship proceedings, having to appoint a legal guardian for somebody when the principal becomes incapacitated. Florida law does not like it when a bank unreasonably rejects a POA. So the law goes on to say that a bank cannot unreasonably reject a POA. An agent that's seeking, let's say, walks in a bank trying to enforce the POA against a bank, where the bank has unreasonably rejected the POA, can be awarded their cost and attorney's fees. So the bottom line is a bank that rejects a POA does so at their own peril, okay? So when can a bank reject a POA? Well, again, this law in Florida that we have now, it allows a bank to reject a POA within a reasonable time in the following situations. Number one, let's say the bank isn't otherwise required to engage in a transaction with the principal. So if the bank was dealing directly with the principal, if it's a matter or a transaction that the bank isn't required to engage in, well, an agent can't come in and force the bank to engage in that transaction just because the agent's holding a POA. Number two, the bank has knowledge that the POA has been revoked, or if not revoked, that the agent's authority has been terminated or suspended or curtailed under the POA. Number 3, the bank makes a timely request, a request that's timely, request an affidavit in an English translation or an opinion of a lawyer about the POA. The bank makes that request and the agent refuses to give it, okay? And that's usually like an opinion from a lawyer saying the POA is valid. Another situation where the bank can go ahead and reject a POA is if the bank relies or believes, I should say, in good faith that the POA is not valid or that the agent doesn't have the authority to do what the agent's trying to do. And then finally, if the bank sends a report off to the state adult protective services or knows that someone else has sent such a report off to the state, which says in good faith that there's a belief that the principal, the person that put together the POA, may be subject to physical or financial abuse, neglect, exploitation, or abandonment by the agent. So those are the sort of the limited situations where a bank can refuse a POA or a power of attorney. So if you'd like to know more about how banks and under what situations they can refuse a POA and whether you can challenge that or dispute that, and maybe if you'd like to know how we can help, we'd love to talk to you. We encourage people to reach out and schedule a free 15-minute discovery phone call, introductory phone call, where we get to know each other and you get to share with us what your specific concern is, so that way we can tell you if we can help you. Go ahead and book it on the Book Now button on the Facebook page, or go ahead and just call us at the office, Google us, Legacy Planning Law Group. Again, this call is complimentary. Hey, if you've enjoyed this video, I'd kindly ask you to please like it, or better yet, to share it with your friends. So just in closing, I hope you've enjoyed this talk on the topic of whether a bank can refuse the POA, and if so, whether you can dispute it. I plan on giving another Facebook Live talk next Thursday at about this time, same day and time, a little different topic from week to week. So if you're thirsty for knowledge, you come to the right place, and we will certainly quench your thirst. So Bill O'Leary signing off for now. On behalf of everybody here at my firm, we call ourselves Team Legacy. Go make it a great day and make it a better world. Have a good weekend.